In our last discussion, we talked about the importance of persons and why it occupies the first part of our civil code. We also talked about Article 2 or the rule when laws take effect. In case you missed it kapatid, pause mo muna to and go to the previous lecture in the description down below. Laws must be published before they can take effect. This is the rule under Article 3 kapatid. Article 3 provides that ignorance of the law excuses no one from compliance therewith. Once a law is published, it is conclusively presumed that everyone knows the law. Again, marami na namang big words dyan kapatid, so let's break them down. When the law talks about a presumption or that something is presumed, it makes a conclusion. This conclusion is based on a fact or group of facts which, when taken together, clearly point to something. A presumption is an assumption as to the existence of a fact or set of facts. Most of them are laid down by law. Others come from ordinary human experience or common sense. Halimbawa, kung sa iyong pagsilip sa iyong bintana may nakikita kang makapal at maitim na usok na nanggagaling sa bubong ng iyong kapitbahay. Maraming mga nagsisigawan sa labas at nakakaramdam ka ng init mula sa iyong bintana kahit nakatodo ang aircon nyo sa kwarto. Based on this set of facts, we can come to the conclusion na may sunog. Presumptions operate in the same way. Presumptions always go into the proof or more specifically, the burden of proof. There are several kinds of presumptions scattered throughout our laws. The most common in the civil code are presumptions juris tantum. A presumption juris tantum is a prima facie or face value presumption. They are also called rebuttable or disputable presumptions, and we will discuss more of them when we go to evidence or whenever we encounter them as we go along. Heto ay mga conclusions na pwedeng banggain, salungatin at patunayan na hindi naman totoo. Pinakamagandang halimbawa dito ay ang Article 735 which provides that if goods are lost, destroyed, or deteriorated, common carriers are presumed to have been at fault or to have acted negligently unless they prove that they observed extraordinary diligence as required in Article 1733. Ibig lang sabihin yan kapatid ay kung may binili ka sa Lazada at dumating ang parcel mo na wakwak ang supot, bawas ang laman o halatang inunahan ka na ni kuya na mag-unboxing. There is now a disputable presumption na ang courier ang may kasalanan at dapat managot. However, this conclusion can be rebutted, refuted, or otherwise contradicted by the courier. He is allowed to present evidence that the item was like that even before he received it. This is the difference between another kind of presumption, the conclusive presumption. A conclusive presumption or juris et de jure is conclusive. The law does not allow the presentation of evidence to contradict the conclusion. Kapag nilatag ng batas na conclusively presumed na yan, given na yan kapatid at hindi na pwedeng pagtalunan. In Article 3 of the Civil Code, we have the conclusive presumption. Again, isang fact na hindi na pwedeng salungatin or pagtalunan pa na kapag ang batas ay nailimbag, walang excuse kapatid para sa taong hindi susunod. If for whatever reason Congress passes a law prohibiting the wearing of the color purple and the penalty therefore is 6 months imprisonment and a fine of 5,000 pesos, and this law was published in the official gazette or a newspaper of general circulation, then if a person is apprehended for wearing the color purple dahil diehard fan daw siya ni Black Mamba, this person cannot come to court and say he does not know of any law that prohibits the wearing of purple shirts. Hindi niya pwedeng ilaban na, Your Honor, hindi ko po alam. That is the meaning of ignorance of the law excuses no one from compliance therewith. This rule admits of several exceptions. Pero intro muna tayo. All of this and more coming right up. Hi, my name is Lex and welcome to Lex in Motion. In this channel, I'll be helping you build your competence, confidence, and capability in law school. Start today by hitting the subscribe button below. New episodes are posted every Friday. Not knowing the law or a mistaken understanding of the law admits of 3 exceptions. They are, number 1, Article 526 provides that mistake upon a doubtful or difficult question of the law may be the basis of good faith. Number 2, Article 1334 also provides that mutual error as to the legal effect of an agreement when the real purpose of the parties is frustrated may vitiate consent. Number 3, Article 2155 also provides that payment by reason of a mistake in the construction or application of a doubtful or difficult question of the law may come within the scope of solutio indebiti. In all of these exceptions, kapatid, what is common is that there is a mistake. Pangalawa, this mistake is based on a doubtful or difficult question of the law. Third, this mistake produces effects which are nevertheless recognized by the law. Higit sa anumang requisite, kapatid, ang pinakamahalaga dito ay ang element ng doubtful or difficult question of law. Finally, one more point, kapatid, bago natin iwan ng Article 3. The rule is that once a law is published and later on becomes effective, we are bound to comply with it. Ang rule na yan ay hindi mag-a-apply to foreign laws. When a foreign law is used as a basis to terminate the employment of an OFW or to prove the validity of a divorce obtained in the US, then that foreign law must be specifically alleged and proved in our courts. Our courts cannot simply take judicial notice of them or accept them as the party who relies on them claims them to be. If a foreign law is not properly proved or pleaded in our courts, then our courts will simply presume that the foreign law is the same as our local laws. This principle in international law is called the doctrine of processual presumption or the doctrine of presumed identity approach. You will encounter this principle as you study conflict of laws a little in alternative dispute resolution, sometimes in constitutional law, and often here in persons. Huwag kang mag-alala, kapatid, dahil ang kadalasang tanong dyan ay simpleng definition lang. Or as I remember from many years ago, itinatanong din kung paano o dapat i-prove. This definition comes to us from the Supreme Court in the case of Orion Savings Bank versus Suzuki. This is a case of specific performance and damages filed by Shigekane Suzuki against Yung Samkang and Orion Savings Bank. Si Shigekane Suzuki ay isang Japanese national at binili niya ang condominium unit plus yung parking slot ni Yung Samkang, isang Korean national. Nag-down muna si Suzuki ng 100,000 at tapos binayaran na niya yung balanse niya na 2.7 million pesos at saka na niya pinarenovate ang loob ng condominium unit. Maaaring at this point, kapatid, ay nagtataka ka na kung bakit ang isang foreigner ay pwede palang magkaroon ng real property dito sa ating bansa. Bawal daw yon ayon sa ating constitution. The rule under our constitution is that foreigners cannot own land in the Philippines except for properties that were acquired before the 1935 Constitution and for properties acquired through succession. Meaning, kung may mga pinsan ka na nakalaro mo noong elementary at high school na maganda na ang buhay sa Canada at naging mga Canadian citizens na, sila, kapatid, ay pwede pa rin pamanahan ng lolo at lola mo. Pwede pa rin silang maging owners ng real property dito sa Pilipinas kahit pa yung mga kapatid nila na sa Canada na ay pinanganak. Another exception is the one laid down in the Condominium Act, which allows foreigners to buy up to 40% of any condominium building provided that the 60% is owned by Filipinos. This stems from the principle that a foreigner can own the house but not the land on which it is built. Remember this, kapatid, dahil may encounter mo ulit ang rule na to sa property, sa succession, at sa obligations and contracts. Going back to our case, kinulit ni Suzuki si Kang na ibigay na sa kanya yung title ng kondo at para mapatransfer na, total bayad naman na siya. Oo lang ang sagot ni Kang hanggang sa malaman ni Suzuki na nakaalis na pala siya sa bansa. Later on, Nalaman ni Suzuki na nasa bangko ang titulo, hawak ng Orion Savings Bank. Pero ayaw nilang ibigay. Natural lang na hindi nila ibibigay dahil hindi naman nila natanggap mula kay Suzuki ang pera. This prompted Suzuki to file a complaint for specific performance plus damages. He is now petitioning the court, Your Honor, utusan niyo po si Kang o ang bangko o silang dalawa na ihatid na sa akin ang title dahil fully paid na po ako. To this, Orion Savings Bank raised several defenses. Let's focus on the most important. The deed of sale executed by Kang in favor of Suzuki is null and void. Under Korean law, any conveyance of a conjugal property should be made with the consent of both spouses. The Supreme Court, speaking through Justice Mendoza, discussed that immovable properties are governed primarily by the law of the place where they are situated. This is because immovable properties cannot be moved. This is called the principle of lex loci resite. The title to or any conveyance or transfer of the property must necessarily be governed by the law where the property is situated. Property relations between spouses are governed principally by the national law of the spouses. However, the party invoking the application of a foreign law has the burden of proving the foreign law. The foreign law is a question of fact to be properly pleaded and proved, as the judge cannot take judicial notice of a foreign law. He is presumed to know only domestic or the law of the forum. To prove a foreign law, the party invoking it must present a copy thereof and comply with sections 24 and 25 of Rule 132 of the Revised Rules of Court. In this case, Orion Savings Bank submitted a certification from the Embassy of the Republic of Korea to prove the existence of Korean law. This falls short from what the law requires. If there is one thing, kapatid, you should take away from the case of Orion Savings Bank versus Suzuki, it is this. Where a foreign law is not pleaded or even if pleaded is not proven, the presumption is that the foreign law is the same as the Philippine law. Sa kanilang deed of absolute sale, kapatid, isinulat ni Kang ang pangalan niya bilang Yung Sam Kang married to Hyun Suk Jung. This phrase in our local laws does not mean that the condominium unit was actually owned by Kang and his wife. It only tells us that Kang is the owner and that Kang is married to Hyun Suk Jung. Applying our Philippine laws, therefore, the title must now be delivered to the buyer, Shigekane Suzuki. Moving on, Article 4 of the Civil Code provides that laws shall have no retroactive effect unless the contrary is provided. Not a lot of big words here, kapatid, so hopefully mabilis lang to. Whenever the law mentions retroactive effects, ang ibig sabihin lang yan, kapatid, ay ang bisa ng batas ay bumabalik mula sa petsa ng kanyang effectivity pabalik, backwards in time. Ang kabaliktaran naman ay prospective, meaning the effects come into play forward in time. For example, nagpasa ang Congress ng isang batas na lahat ng healthcare workers ay magkakaroon ng minimum daily wage na 1,200 pesos magsisimula sa June 1, 2020. Applying Article 4, we know that the new minimum wage will only begin to apply on June 1, 2020. Pwede ba, kapatid, na mag-rally ang mga nurse sa kanilang mga HR department at humingi ng back wages or salary differential para sa mga pinasok nila mula May 1, 2020 to May 30, 2020 on the strength of this new law? The answer is Article 4 because it provides that laws shall have no retroactive effect unless the contrary is provided. Nagsisimula yan sa Latin maxim na lex prospicit, non respisit. The law looks forward and not backward. As I've mentioned in our previous episodes, the study of the law is the study of the exceptions. Let's take a look at exceptions to the rule on prospectivity. The first exception is when the law itself provides for its own retroactivity. Kung ang batas na mismo, kapatid, ang nagsabi na mag-a-apply siya backwards in time, then we must apply the law retroactively. In our earlier example, if the new minimum wage law provides for retroactivity until January 1, 2020, then the healthcare workers must be paid the difference between their daily rates and the new minimum wage from January 1, 2020 up to the date of the law's effectivity. There are, however, exceptions to this exception. Even if when the law itself provides for retroactivity, it cannot be given retroactive effect if the law will become A. An ex post facto law, B. The new law will result in the impairment of obligation of contracts. Ayon sa ating saligang batas, lahat tayo ay may karapatan laban sa mga ex post facto law. Ang ex post facto law sa madaling salita ay mga batas na ginagawang krimen. Ang isang bagay na dati naman ay legal. Walang issue sa pagbabawal sa isang action or activity. Nagiging issue siya, kapatid, kung damay pati ang mga action or activity bago maipasa ang batas. Halimbawa, nagpasa ang Congress ng isang batas na bawal ang paggawa, pagbebenta at paggamit ng mga hand sanitizer na may halong glitters. Kunwari lang, kapatid, at ikaw ang number 1 seller sa Shopee ng mga sanitizer na may mga glitters. Kung ang batas ay nailimbag ng April 30 at nagsimula ang effectivity niya ng May 4, walang issue dito, kapatid. Hindi ka magiging kriminal dahil lang bet mo ang mabango at makukulay na hand sanitizer. Nagiging issue lang ito kung ang batas ay nagsasabing lahat po ng previous sellers ay dapat ding makulong. An ex post facto law stems from the rudimentary concept of fair play. You cannot be held criminally liable for an act which was not a crime at the time you committed it. Remember this concept, kapatid, because you will see it again in constitutional law and remedial law. There is a second kind of an ex post facto law, and that kind decreases the quantum of proof for conviction. The way to understand it is that all criminal offenses are composed of elements of a crime. For example, crime X needs elements A, B, and C. If Congress passes a law that allows conviction for crime X based only on elements A and B, then wala pa ring issue dito, kapatid. But it cannot be given retroactive effect because it is an ex post facto law. The second exception to the exception is the impairment clause. It means that Congress can pass laws that would affect how parties to a contract relate with one another. Again, walang issue dito, but this new law cannot be given retroactive effects. We will discuss more of this once we get to the impairment clause. Another exception to the rule that laws must only be given prospective effect is when penal laws are favorable to the accused. This means, kapatid, that if Congress reduces the penalty for the crime of robbery with homicide from reclusion perpetua to reclusion temporal, then the new penalty should also be applied retroactively. The exception to this exception is when the convicted felon is a habitual delinquent. Habitual delinquency is a technical term which you will encounter in Criminal Law 1 and later on in Criminal Law 2. At its essence, a person is a habitual delinquent when the following are present. 1. The person has committed 3 crimes. 2. The crimes involved are crimes of robbery, theft, estafa, or falsification. 3. Less than 10 years have elapsed from the conviction for or release from crime number 2 and the commission of the third crime. The wisdom of the law here is based on the classical theory of criminal law. Lahat ng krimen ay may katumbas at karampatang kaparusahan. Kung ang ating kriminal dito sa ating halimbawa ay walang nasang magbago, nakakalabas lang niya ay muli siyang nagnakaw, hindi na dapat siya mapagbigyan pa ng mababang penalty. That is the meaning of the exception to the exception based on habitual delinquency. Pangatlong exception to the prospective application of the laws comes from the case of Systems Factors Corporation versus NLRC. In this case, the Supreme Court ruled that remedial statutes or statutes relating to remedies or modes of procedure which do not create new or take away vested rights but only operate in furtherance of the remedy or confirmation of rights already existing do not come within the legal conception of a retroactive law or the general rule against retroactive operation of statutes. Statutes regulating the procedure of the courts will be construed as applicable to actions pending and undetermined at the time of their passage. Procedural laws are retroactive in that sense and to that extent. The retroactive application of procedural laws is not violative of any right of a person who may feel that he is adversely affected. The reason is that as a general rule, no vested right may attach to nor arise from procedural laws. Pang-apat na exceptions, curative laws. Curative statutes are enacted to cure defects in a prior law or to validate legal proceedings which would otherwise be void for want of conformity with certain legal requirements. They are intended to supply defects, abridge superfluities, and curb certain evils. They are intended to enable persons to carry into effect that which they have designed or intended, but has failed of expected legal consequence by reason of some statutory disability or irregularity in their own action. Ang isang curative law ay ipinapasa para gamutin kung anumang mali sa isa pang naunang batas. They are there to cure, to correct, to validate acts which before the curative law passes into law are invalid acts. Kung ang tanging purpose ng curative law ay ayudahan ang mga unang mali, then by its very essence, we have to make sure that its effects reach back in time to the time before it was enacted. This is why the Supreme Court teaches us that curative statutes, by their very nature, are retroactive. The last exception comes to us from a very old case decided over 100 years ago, Bona versus Briones. I don't want to discuss the details of the case, kapatid, maguguluhan ka lang sa rules ng succession. The will of Francisco Briones was executed based on the rules then in force. Let's just call them kapatid 1911 rules, which provides that a will is nevertheless valid even if it does not have an attestation clause. If it can be proven that all of the requirements in the attestation clause are present, that the signing of the will by the testator and the witnesses, and that the signing happened in the presence of the testator and of the witnesses, and that the same is attested to by two or more credible witnesses. Basta nandyan yan, valid ang will according to the 1911 rules. For whatever reason, the will was disallowed by the lower court. The appeal was decided by the Supreme Court in 1916, at which time kapatid ay meron ng bagong rule, which now requires that each of the pages of the will must be written in words in the upper part of each page, plus an expanded attestation clause, which we will discuss later in succession. The Supreme Court ruled that it is well known that the principle that a new law shall not have retroactive effect only governs the rights arising from acts done under the rule of the former law. But if the right be declared for the first time by a subsequent law, it shall take effect from that time even though it has arisen from acts subject to the former laws, provided that it does not prejudice another acquired of the same origin. Sa unang tingin parang malabo ang rule kapatid, pero mapapadali natin yan once we break it down. The general rule is that laws must be applied prospectively. The exception is that they can be applied retroactively if they create new substantive rights. Gaya ng case ni Bona versus Briones, kung saan involved ang rights to the succession. The exception to the exception is the rule that creates substantive rights cannot be given retroactive effects if it prejudices, removes, or otherwise changes the rights one acquired from the same origin. Ang last will ni Briones ay nagpapamana sa kanyang pangalawang asawa, si Monica Bona. Kung pagbabasihan lang natin ang 1916 rule, hindi siya mapapamanahan dahil kulang sa requirements ang will na ipinagawa ni Francisco Briones noong 1911 under the 1911 rule. This is where the exception to the exception should apply. To recap the rules, at eto kapatid ay ang part na pwede kang mag-screenshot o magsulat. The general rule is that laws must be applied prospectively, moving forward. The exception is that the laws may be given retroactive effect, moving backward. The exceptions are: 1. When the law so provides. The exceptions to this exception are ex post facto laws and laws that impair the obligation of contracts. Number 2. When a penal law is more favorable or beneficial to the accused. The exception to this exception is when the convicted felon is a habitual delinquent. Number 3. When the law is remedial or procedural in nature. Number 4. When the law is curative in character. Number 5, when the law creates new substantive rights, so long as they do not prejudice, change, or remove another right from the same origin. I think we can stop here, kapatid. If you would like to see part 3 of this episode, please let me know by typing yes in the comments below. Finally, there is a quiz, kapatid, para naman masubukan natin kung may natutunan ka sa ilang minutong nagdaan. Post your scores below and please do not copy and paste the questions para hindi naman ma-spoil para sa iba. Thank you so much for watching. Like and share this video for good law school karma, and I will see you next Friday.